and throwing away the key that this bill is absolutely the cornerstone of what we normally would a country with a bill like this, we would correctly call an authoritarian state.
There has been a lack of an outcry, though, given that, if that is the case.
There's never been a single hearing on this bill. No one even knows about it.
Is this just part of this sort of this almost very quiet lurch to the sort of state that you suggest? I mean, we have actually a list of all the legislation that preceded this bill. The Patriot Act was passed after 9/11. Among those provisions, it made it easier for law enforcement to access telephone and email communications, financial and medical records. Then there was the Military Commission Act 5 years later. That allows the government to indefinitely detain non-citizens as enemy combatants. July 2008, an updated version of the Foreign Intelligence Surveillance Act was signed into law. That expanded the government's power to conduct surveillance without a warrant from a court. All these passed without much of a whimper. The Patriot Act was extended actually with full bipartisan support. Is this just how it's going to be, Sebastian Gorka, and this is how it has to be because we are at war? Is that what you're saying?
Think about the actual source for all this legislation originally, the legal system we're talking about. We're talking about the Hague and Geneva Conventions, the international laws that were brought 80, 70 years ago. We're talking about the national security system that was built in the United States in 1947 with the National Security Act that created the Department of Defense, that created the CIA. What was the actual circumstance for that law and for the Geneva and Hague Conventions? Who signed them? Nation states. Nation states that were trying to regulate combat between themselves. That's the nature of the international laws of war, and that is the nature of the National Security Act that shaped the architecture that America tried to fight Al-Qaeda with and failed. This system is inadequate, and I think that's what the NDAA is trying to bridge.
I was suggesting this wasn't just going to be used against...
But no, the idea that this is going to be rampantly used against eco-terrorists and anybody who lies on an immigration form, they'll be locked away for the next 50 years, I think that's just not, that's amusing. This is going to be used for serious...
It's already the case that First Amendment protected activism has been prosecuted as terrorism. There was a case before the Supreme Court about it.
There's no reason to believe it's not going to be used that way. You know, Senator Feinstein did introduce an amendment to this that would exempt Americans from these provisions explicitly, and that was defeated.
Why would you exempt Americans if you look at Anwar al-Awlaki? Why on earth would you be fighting to exempt, a constitution
and
a
lots of people are
constitution and a legal system is based upon a social contract. That's the nature of the whole system of Western democracy, a social contract.
But again, I have to return to the point. I mean, this example of al-Awlaki shows how absurd perhaps this debate is, because the fact is the executive already takes on extraordinary powers. And as far as again, it's not about detention. This is about killing a U.S. citizen without any...
But
the case is fascinating. This is an individual who was a U.S. citizen. But what happened to him? He abrogated his normal access to the due process in this country.
Who decided that?
He declared a review process. A review process which was run by the executive.
You said you're in favor of checks and balances.
We have, but when he's in Yemen, how are you going to bring him to a court?
Well, I'm more concerned about U.S. citizens within the United States for whom we do have courts available that are being actively cut out of the equation by this act of Congress. There is and it's important that we're talking about on the basis of accusation. You're presuming the facts in any given case as presented by the executive branch, but that's why we have a judiciary, because we don't trust prosecutors to make decisions about who should be locked up.
But in conclusion, Admiral, though, does it not worry you that the only reason the President might veto this bill is simply because he wants as much power as possible, and not necessarily because he has a problem with the constitutionality of indefinite detention for Americans? As Carl Levin himself said, it was the Obama administration who wanted Americans to be indefinitely, or allowed to be indefinitely detained in this bill.
You know, on the one hand, the President ought to, in his capacity as Commander-in-Chief, ought to be given very broad authority. On the other hand, he shouldn't be required to prosecute people in a particular location. And as the constitutional lawyer, I think that the President is offended by the concept of indefinite detention of Americans.
Thank you very much for joining us, Admiral Hudson.
That's quite all right. Thank you very much for having me.
Shahid Butler and Sebastian Gorka, thank you as well. That's it from the team in Washington, D.C., but we want to hear from you. Tell us the stories that you think we should be covering. Send your ideas directly to us at insidestory@aljazeera.com.